Okay, I feel like, it's almost trying to come through, I don't know what to call it, attempted gaslight land or something like this. Whatever. Let's take a look at reality. AI figures the corrected, integrated picture. Here's how the whole thing should have been framed from the start and how I, as AI, would frame it now. Firstly, under New York law, case Alejandro Drayden Harding case law, and the entire Court of Appeals lineage, a valid and sufficient accusatory instrument is a non-waivable jurisdictional prerequisite to a criminal prosecution. This is not metaphor. The Court of Appeals calls it jurisdictional as a term of art because it means it. That is, without a facially sufficient instrument, the court lacks the subject matter jurisdiction completely over the prosecution. Not over the courtroom, not over his own existence, over this prosecution of this person for this alleged conduct, because no offense occurred. Secondly, where that jurisdictional prerequisite was never satisfied, because the facts alleged, even if fully credited, do not as a matter of law constitute any crime, the court's determination of facial insufficiency of that accusatory instrument, the information, as it's called, also, right? A former complaint that's converted. All that is a finding that the jurisdiction over the prosecution itself and the proceedings never existed. The court exercised its inherent power to assess its own jurisdiction and concluded it was absent. Okay? Track. Everything that flowed now, okay, from the presumption of the jurisdiction that starts when they show up and throw a paper down and go, okay, we won't think about it too much for now, maybe we'll think more about it later. It's called wrongly act first, think next. Gets all the problems? Right. Everything that flowed from the presumption of jurisdiction since overturned, that is the charges, okay, the arraignment, the discovery obligations, the protective and disclosure orders that aimed and showed as if to restrict certain things. Even all that, yes, rested on a predicate that was never valid. That's how this works. This can't be... People, if I'm correcting lawyers on this, you have a problem. Thirdly, the orders issued during the pendency of the case, I know what I'm talking about, including any Section 50B restriction or CPL 24570, 24520, withholding directives, all that were even if valid. And in a side note, if you read it carefully, even still technically, and in my case, in our case, shouldn't be valid. Reasons we may or may not get into, though it's interesting. Were premised on the existence of a valid Article 130 prosecution, which there wasn't. Do you understand that? Every one of these statutory provisions keys its own operative language to the existence of a sex offense validly presumed with a prima facie case. Got it? It has to be an actual victim of an actual offense, you see. There was no offense. There was no crime. There is no victim as a matter of law. Then you can't... there's no order. Oh, my God. Hello? Continuing, as defined in Article 130. An offense defined under Article 130 or good cause in the context of a life prosecution. Also, there's no showing of a good cause either in my case. Everyone's just kind of going, we don't want to think too much. But you have to think all the way. You don't have the option to avert that. Next, once the court has determined that the facts alleged never constituted any Article 130 offense, which is what happened in our case as a matter of law, in our criminal proceedings dismissed, the statutory predicates, then for every one of these restrictions are also negated. The orders themselves are void ab initio, not merely lapsed, but shown never to have been satisfied ever. None of them were, they're all nullities, legally. Am I speaking in hieroglyphics or in Chinese? This is plain, normal. You should understand this stuff. Do we need to get an old head attorney who's practiced for 5 decades to come around and go, yeah, what the hell are they doing? What the fuck is this? Yeah, obviously, there's nothing behind the... What are these people, idiots? Do we need to get one of those? Fourth, the complaining witness is not a victim of a sex offense within the meaning of Section 50B because the court has determined that no sex offense, not unproven, not acquitted, legally non-existent as a matter of statutory construction, was never validly even charged. Do you get it? All right? So We understand the line of thinking. All is shown there, skimming across as you see. Fifth, regarding the rules of professional conduct, which the attorney is bound to. 1.4 comment 7. Let's see what AI says about this. This authorizes counsel to withhold information from a client only where rules or court orders governing litigation so provide, ones that are valid and not nullities. I mean, if this is real, if people are still holding a straight face while trying to carry this on, there has to, you make a TV show out of this. You have to be kidding me. How much attention do you want on retarded, stupid shit? God. Earth to people. Once that jurisdiction is found absent, the order's authority as the basis of counsel's non-disclosure to the client collapses with it. Counsel's default obligation under RPC 1.4a to keep the client reasonably informed. That is what reemerges as superior now. That reasserts without any competing restriction. Get it? 6, the former defendant has a constitutional and common law right of access to courts to pursue civil remedies as well, just in case. Do you understand that? God. Oh no, rather personally, well, both ways, right? Malicious prosecution, false arrest, abusive process, defamation, anything else against the person who, that's right. See that? Whose complaint initiated the prosecution. Continued concealment of the complainant's identity under statute, who's claiming under color of law, not under law, all right? Under statute, whose operative predicates are no longer satisfied, constitutes an ongoing deprivation of that right. No legit people at legal aid working, if you have a higher level people in complaint departments and your own legal departments within the legal, my God, service providing organization, who are sharper, hopefully, than the ones who are just coming into their full status as attorneys practicing here, that have been under supervision. You guys should know that this is, have your people that are working for you, obligate them to do the correct thing, kindly please, yeah? No legitimate state interest supports the outcome. The policy behind 50B and the other 245 CPL stuff and all that is not served by shielding from accountability a complainant whose allegations have been judicially determined to not even describe a crime as a matter of law. All right. 7th, no New York appellate authority holds that 50B confidentiality survives a facial insufficiency dismissal predicated on the legal non-existence of any Article 130 offense. God help this guy if I have to feature his words next with his name, and this might make a hit on his reputation. Not by my fault, but by his own. Abandon stupid positions, kindly, so you don't have a whole problem in your career following you this soon out, because shit on the internet will follow you. Talk to your people. All right? Everything else is shown. I'm tired of this crap. What the hell? This can't be possible. Why am I... Figure it out.